These autopsy reports were sealed, locked away by court order in the state of Washington, where Spokane County forensic pathologists conducted the examinations. For well over a year after 4 young people were killed inside a rental house on King Road in Moscow, Idaho, those documents existed but were unreachable. The families knew their children were gone. What they did not have full access to was the complete clinical record of what had been done to them. When those reports were finally unsealed, what they contained was not speculation. It was not reconstructed theory. It was the formal, documented, professional assessment of forensic pathologists who examined the physical evidence directly and committed their findings to a permanent legal record. That record is now public, and tonight, we are going through all of it. If you are new here and you believe that victims deserve to be named clearly and that truth matters more than convenience, welcome to Midnight Evidence. Hit that like button right now, because this video took serious research to build, and subscribe so you never miss a case breakdown the moment it matters. Now let us go back to the beginning, because to understand why these autopsy findings carry the weight they do, you have to understand exactly what was lost, what was locked away, and what 4 families endured, while the answers existed in sealed filing cabinets and they were not allowed to see them. Kaylee Goncalves was 21 years old. She was a marketing student at the University of Idaho, a daughter, a best friend, a young woman described by the people who loved her as vibrant, fiercely loyal, and full of direction. Madison Mogen was also 21, Kaylee's lifelong best friend, her roommate on King Road, someone who had grown up alongside her and chosen to build a chapter of her life in the same place. Xana Kernodle was 20, also a marketing student, a resident of the same house, a young woman whose boyfriend had come to stay with her that night. Ethan Chapin was 20 years old, a recreation and tourism management student, a member of the Sigma Chi fraternity, a young man who was visiting his girlfriend and was not supposed to die in that house. He did not live there. He was simply there. And that is where the night of November 13th, 2022 ended, for all 4 of them. 2 other people were inside that house. Dylan Mortensen and Bethany Funke were both residents of 1122 King Road. They were on a different floor that night. They were not harmed. Law enforcement cleared them as suspects almost immediately and treated them as witnesses. The question of why they were not encountered, why whoever moved through that house in the early morning hours of November 13th reached some floors and not others, is a question the forensic record helps answer in ways that matter enormously for understanding what kind of act this was. The bodies were not discovered until nearly noon. A 911 call was placed at approximately 11:58 in the morning, more than 7 hours after the estimated time of death. When Moscow Police Department responded and entered the house, they found 4 victims on 2 different floors, Kaylee and Madison on the 3rd floor, Xana and Ethan on the 2nd, Dylan and Bethany on a separate level, alive, having been inside the house the entire time. Moscow, Idaho, is a small university town. Its police department had no prior experience with a crime of this scale. Within days, the Idaho State Police and the Federal Bureau of Investigation were brought in to assist. And within those same early days, law enforcement made a public statement that would define the next 6 weeks of the community's life. There were no suspects and no motive. That communication decision, made to protect the investigation's integrity, created a vacuum. And into that vacuum rushed social media speculation, misinformation, fear, and a level of public anxiety that fundamentally altered daily life for thousands of students who were still trying to attend a university while wondering if whoever had done this was still among them. The 4 autopsy reports that would eventually be sealed were conducted by Spokane County forensic pathologists. Spokane County, Washington was the nearest jurisdiction with the forensic infrastructure capable of handling examinations of this complexity and gravity. What forensic pathologists do, in the context of a criminal prosecution, is often misunderstood by those outside the legal system. They do not simply document that a person has died. They translate physical evidence into legal language. They establish cause of death. They establish manner of death. They document the characteristics of wounds, the nature of injuries, the patterns and distributions that allow prosecutors to construct a specific argument before a jury. In a first-degree murder case where the state must prove not just that the defendant caused a death, but that they did so with deliberate premeditation, the forensic record is not background material. It is the foundation upon which the entire prosecution is built. What the unsealed autopsy reports established across all 4 victims was that the injuries sustained were consistent with a single-edged fixed-blade knife. That finding directly connects to the probable cause affidavit filed at the time of the eventual arrest, which specifically referenced a K-bar-style knife. A K-bar is a combat and utility knife with a fixed single-edged blade, originally developed for military use, and widely recognized within forensic and law enforcement contexts. When forensic pathologists document wound characteristics consistent with a specific blade type, and prosecutors separately possess physical and DNA evidence tying that blade type to a specific individual, those 2 threads converge in front of a jury in a way that is exceptionally difficult to challenge. The injury patterns documented across the 4 victims were not identical. They varied in distribution, in orientation, in severity, and in what they suggested about the nature of each individual encounter. That variation is itself forensically meaningful. It tells investigators something about the sequence in which the victims were encountered that night. It tells them something about the duration of each encounter, about the relative positions of the victim and the person responsible, about whether the victim was stationary or in motion. In a premeditation prosecution, a coherent and reconstructible timeline is not a bonus. It is essential. And the variation documented across these 4 reports gave investigators the building blocks to construct exactly that. Among the most legally and humanly significant findings in the reports were injury patterns on more than one victim, consistent with what forensic professionals classify as defensive wounds. Injuries to the hands, the forearms, the upper extremities. The presence of defensive injuries establishes something that carries weight both inside and outside the courtroom. It establishes that the victim was conscious. It establishes that they were aware of what was happening to them. They were not overcome without any opportunity for response. They recognized what was happening, and they reacted to it. In a capital murder prosecution, the awareness and suffering of a victim during the commission of the crime is directly relevant to the aggravating factors that determine whether a case meets the threshold for death penalty eligibility. It speaks to deliberateness. It speaks to duration. It speaks to the nature of what was done and what it required of the person doing it. There is another dimension to the forensic picture that connects directly to the question of what kind of act this was. The physical layout of 1122 King Road, combined with where each victim was found, and what the injury patterns suggest about the sequence of events, reflects a pattern of deliberate navigation. Someone moved through that house that night and reached specific rooms and specific people. 2 people were also in that house and were not reached. The forensic evidence read alongside the physical structure of the building does not describe the chaos of an unplanned, frenzied encounter. It describes movement that followed a path. For prosecutors, that distinction is critical. Random violence and deliberate, directed violence are treated differently under the law, and the forensic record in this case, according to experienced criminal justice analysts who reviewed the public filings, is more consistent with the latter. The investigation that eventually identified a suspect relied on multiple converging evidence threads, each of which was significant on its own and more powerful in combination with the others. Cell phone data recovered during the investigation placed a device associated with the eventual suspect in the vicinity of 1122 King Road on multiple occasions prior to November 13th, suggesting the property had been visited before the night of the killings. On the night itself, cell phone records placed that same device in the immediate area of the house during the window, consistent with the estimated time of death. Surveillance footage and witness accounts identified a white Hyundai Elantra in the area of King Road on the night of the murders. Law enforcement issued a public appeal for information about that vehicle. It became one of the most discussed details during the weeks-long investigation. That vehicle was later confirmed to be registered to Bryan Kohberger. The most technologically significant element of the investigation involved a tan leather knife sheath recovered from beneath the body of Kaylee Goncalves at the scene. DNA was recovered from that sheath. It did not match any existing profile in standard criminal databases. Investigators turned to investigative genetic genealogy, the same methodology used in the identification of the Golden State Killer, which involves uploading an unknown DNA profile to publicly accessible genealogy databases and tracing family trees outward to identify potential biological relatives of the unknown contributor. That process led investigators to the Kohberger family. Investigators then conducted legally authorized trash pulls at the family home in Albrightsville, Pennsylvania, recovering discarded material containing DNA without requiring a warrant. The familial match was confirmed. Bryan Kohberger's own DNA was subsequently confirmed to match the profile recovered from the knife sheath found beneath Kaylee Goncalves. Bryan Kohberger was 28 years old at the time of the murders. He held a bachelor's degree and a master's degree in criminal justice from DeSales University in Pennsylvania, and was enrolled as a doctoral student in the criminology program at Washington State University in Pullman, Washington. Pullman sits approximately 8 miles from Moscow, Idaho. From his campus, the University of Idaho was a short drive. He was still on that campus during the weeks of the investigation. He was still, by multiple accounts, present in his academic role while the investigation moved toward him. He was arrested on December 30th, 2022, 6 weeks after the murders, at his parents' home in Pennsylvania, where he had traveled for the Christmas holiday. The arrest was coordinated between Idaho authorities, the Pennsylvania State Police, and the FBI. He was extradited to Idaho and charged with 4 counts of first-degree murder and 1 count of felony burglary. The burglary charge reflecting the legal determination that entering the residence with intent to commit a crime constitutes a separate felony under Idaho law. In August 2023, Bryan Kohberger entered a guilty plea. The prosecution agreed to remove the death penalty from consideration. He was sentenced to life in prison without the possibility of parole on all 4 murder counts. He was not required, as a condition of that plea, to provide a motive, a planning account, or any detailed explanation of his actions. The families of Kaylee Goncalves, Madison Mogen, Xana Kernodle, and Ethan Chapin did not get a trial. They did not get the moment in open court where every piece of evidence was laid out, where every question was asked and answered under oath, where a jury returned a verdict the community could witness together. They got a plea, and the man who entered it was not compelled to say why. If this case matters to you, if you believe these 4 names deserve every layer of truth that can still be uncovered, subscribe to Midnight Evidence right now and leave a comment below. The next part goes deeper into what the families said, what the legal system left unresolved, and what this case permanently changed about how we understand justice in America. What the legal system delivered in the Kohberger case was a resolution. Whether it was justice in the full weight of what that word is supposed to mean is a question that 4 families are still living with. And it is a question that every person watching this case from any distance has a legitimate stake in asking. The autopsy reports are public. The guilty plea is entered. The sentencing is complete. Bryan Kohberger is in a cell, and he will remain there for the rest of his natural life. But the conversation about what this case demanded of every institution it touched, and whether those institutions rose to meet that demand, is not finished. It may never be finished. Because some cases do more than end. Some cases break something open, and what spills out of them changes the way an entire country thinks about safety, about accountability, and about what the systems built to protect ordinary people are actually capable of delivering when they are tested at the highest level. This case broke something open. And tonight, in this second part, we are going through exactly what came out. The first place this case changed things was on college campuses, and it happened before the legal proceedings had moved anywhere close to their conclusion. Universities across the United States did not wait for a verdict or a plea before beginning to examine what November 13, 2022 had revealed about the vulnerability of their students. Within months of the Moscow killings, campus security directors at institutions across the country were conducting formal reviews of their protocols, not just for dormitories and university-owned facilities, but for the off-campus residential neighborhoods, where large portions of their student populations actually lived. The University of Idaho undertook a significant review of its own safety infrastructure. Emergency notification systems were evaluated. The relationship between university security personnel and the Moscow Police Department was examined and, in several respects, formally restructured. What those reviews confronted was an uncomfortable reality that extended far beyond the University of Idaho's specific situation. The house at 1122 King Road was a private rental property in a residential neighborhood. It had multiple entry points. It had no security cameras. It had no electronic access system. It was shared by 6 students who had no reason to believe that the ordinary domestic arrangements of their lives placed them in any particular danger. And that profile, a multi-occupant off-campus rental with no institutional security infrastructure, applies to tens of thousands of similar properties surrounding hundreds of universities across the United States. Off-campus housing exists largely outside the direct security reach that universities maintain for their own buildings and grounds. Students who choose to live off-campus are, in a practical sense, operating without the safety infrastructure that institutional housing provides. After November 2022, a number of universities began extending their safety programs beyond their physical boundaries. Initiatives that had previously centered on campus escort services and emergency call stations began expanding their scope to include the residential neighborhoods directly surrounding their campuses. Several institutions began offering subsidized security equipment to students in off-campus housing. Doorbell cameras, reinforced door locks, and window sensors were made available through programs specifically designed in response to what the King Road case had exposed. Others established formal partnerships with local law enforcement to increase patrol frequency in student residential areas during overnight hours. These were not symbolic gestures. They were institutional acknowledgments that the existing framework had a gap large enough for something catastrophic to pass through. At the legislative level, the conversation moved in parallel. State legislators in Idaho and in several other states introduced proposals addressing a range of issues that the case had brought into focus, from landlord obligations in student housing to the standards by which law enforcement agencies are required to communicate with university communities during active criminal investigations. That second point became a specific and pointed debate in the months following the killings. During the 6 weeks between the discovery of the 4 bodies and the arrest of Bryan Kohberger, law enforcement's public communications were limited, measured, and carefully controlled to protect the integrity of the investigation. That approach was legally defensible and investigatively sound. But for the families, the students, and the broader community living inside that period of uncertainty, the restraint came at a significant human cost. The question of how much information law enforcement owes to a frightened community during an active investigation, and how quickly that information should be released, does not have a clean answer. But this case forced that question into a national conversation in a way that is producing real policy debate. None of these changes restore what was taken on November 13, 2022. But they represent something that matters. A system examining its own architecture and attempting, however imperfectly, to learn from what it failed to prevent. The second area where this case changed the national conversation is one that most Americans had never engaged with before Bryan Kohberger's name appeared in the news. Investigative genetic genealogy is the technique that ultimately connected Kohberger to the DNA recovered at the crime scene, and understanding how it works is essential to understanding why this case will be studied in forensic science programs, law schools, and legislative chambers for years to come. Traditional forensic DNA matching works by comparing a profile developed from physical evidence against profiles already stored in criminal databases. In the United States, the primary system is CODIS, the Combined DNA Index System maintained by the Federal Bureau of Investigation, which contains profiles from individuals who have previously been convicted of qualifying offenses and had their DNA entered into the database. If the contributor of a crime scene DNA sample is in that system, a direct match can be returned. If they are not, the search produces nothing. Bryan Kohberger had no prior criminal record. A traditional CODIS search would not have identified him. What investigators turned to instead was a methodology that begins not with criminal databases, but with the vast, publicly accessible genealogical databases where millions of ordinary people have voluntarily uploaded their DNA profiles to trace ancestry and find family connections. When an unknown DNA profile from a crime scene is run against one of these databases, investigators are not looking for an exact match. They are looking for partial matches, genetic profiles that share enough material with the crime scene sample to suggest a biological family relationship. From those partial matches, trained genealogical investigators build outward, constructing family trees, narrowing the field through additional demographic and geographic research until a manageable group of potential contributors has been identified. In the Kohberger case, this process pointed investigators toward a specific family line. Through additional investigative work, Bryan Kohberger emerged as a person of interest from within that family structure. A conventional DNA sample was then obtained and compared directly to the crime scene profile, confirming the match. The tan leather knife sheath recovered from beneath Kaylee Goncalves, the sheath that had appeared in the probable cause affidavit and whose significance had been apparent to investigators from the earliest stages of the case, contained the biological evidence that ultimately broke the investigation open. The implications of investigative genetic genealogy reach far beyond this case. The technique has now been applied successfully to dozens of cold cases, crimes that occurred years or decades earlier, where physical evidence had been preserved, but no criminal database match had ever materialized. Families who had waited 20 or 30 years for answers have received those answers because of this technology. That is not a minor achievement. That is the kind of outcome that demonstrates the genuine power of scientific advancement applied to human suffering. But the technique also raises legal and ethical questions that courts and legislators are actively working through, and the Kohberger case sits at the center of that debate. Consent is among the most significant of those questions. When a person uploads their DNA profile to a genealogical database, they are providing consent for that data to be used in the context of finding family connections and tracing ancestry. They are not providing explicit consent for that data to be incorporated into a criminal investigation. And the relatives whose genetic information contributes to an investigative match have not consented in any form. They are simply people who share a biological relationship with someone investigators are looking for, and that relationship becomes, without their knowledge or agreement, a tool used by law enforcement. Several states have moved to regulate investigative genetic genealogy, establishing requirements around judicial oversight, the types of crimes for which the technique can be used, and the circumstances under which genealogical databases can be accessed for investigative purposes. The federal regulatory picture remains less defined. Advocates of the technique point to cases like Kohberger's as evidence of its capacity to deliver resolution in cases that would otherwise remain permanently open. Civil liberties organizations counter that the boundaries of its application must be more clearly defined before it becomes routine practice in investigations of any severity level. Both arguments are grounded in legitimate concerns, and the Kohberger case will remain a central reference point in that debate for as long as the debate continues. This case also forced a national reckoning with how American prosecutors decide when to seek the death penalty, and what the pattern of those decisions reveals about the consistency or the inconsistency of the system that makes them. Bryan Kohberger was charged with 4 counts of first-degree murder in Idaho, a state that authorizes capital punishment and has used it. The case involved multiple victims, documented evidence of premeditation, a forensic record that legal analysts across the political spectrum described as among the most compelling assembled in a capital-eligible prosecution in recent years, and injury patterns that forensic professionals had characterized as consistent with a sustained, deliberate act. By the criteria that Idaho law establishes for death penalty eligibility, this case met the threshold clearly. The prosecution chose not to seek capital punishment. The guilty plea was accepted. The death penalty was removed from consideration, and Bryan Kohberger was sentenced to life in prison without the possibility of parole on all 4 murder counts. Legal scholars who study prosecutorial decision-making in capital cases have documented a consistent pattern across the United States. The decision to pursue the death penalty is not made through a standardized formula applied uniformly to cases that meet defined criteria. It is made by individual prosecutors, in individual offices, weighing combinations of legal strategy, available resources, victim family input, political context, and personal judgment that vary significantly from jurisdiction to jurisdiction and from case to case. The result is a system in which people charged with crimes of comparable documented severity can receive dramatically different outcomes, depending on where the prosecution occurs and who holds the charging authority. This inconsistency has been raised in academic research, in court challenges, and by legal reformers on multiple sides of the broader capital punishment debate for decades. What the Kohberger case did was bring that long-standing criticism into sharp focus for a national audience that was paying close attention. What was notably absent from the plea agreement, and what multiple legal analysts highlighted in the weeks following its announcement, was any requirement that Bryan Kohberger provide a complete and truthful account of his planning, his actions, and his motivation. In other high-profile plea agreements, cooperation requirements have been incorporated as conditions of the deal, requiring the defendant to provide a formal statement, answer investigators' questions, or otherwise contribute to the factual record in a way that serves the family's need for understanding and the public's legitimate interest in knowing what happened and why. No such requirement was included in the agreement that resolved this case. The motive, the planning timeline, the full sequence of decisions that led to November 13, 2022, those remain without a complete public accounting. And for some of the families, that absence is not a legal technicality. It is a wound that the legal process created and then declined to close. The house at 1122 King Road was demolished in December 2023. The University of Idaho purchased the property for that specific purpose, and the physical structure was removed. The address remains. Moscow, Idaho remains. The University of Idaho continues to operate, and students continue to live and study there, as they should. But the community that absorbed what happened in November 2022 is not the same community it was before. That is not a complaint. That is simply the reality of what severe collective trauma does to a place. Communities do not recover from events of this magnitude by returning to what they were. They recover by incorporating the weight of what happened into the way they move forward, which is a different thing entirely, and a harder one. The court filings in this case, the probable cause affidavit, the unsealed autopsy reports, the cell phone data summaries, the forensic documentation compiled across thousands of pages, will be studied. They will be analyzed by legal scholars, examining how a prosecution of this complexity was constructed and resolved. They will be reviewed by forensic scientists examining how investigative genetic genealogy was applied and what it produced. They will be read by campus safety professionals, drawing conclusions about physical vulnerability and institutional responsibility. They will inform legislators drafting the next round of proposals on everything from housing standards to investigative technology regulation. And they will be returned to again and again by journalists and documentarians who understand that the full meaning of a case like this one cannot be captured at the moment it concludes. It requires time and distance, and the refusal to stop asking the questions that the legal process left unanswered. Kaylee Goncalves, Madison Mogen, Xana Kernodle, Ethan Chapin. Those four names are the center of this case, and they always will be. Not the plea agreement, not the forensic technology, not the prosecutorial debate, not the legislative proposals. The four young people who were alive on the evening of November 12, 2022, and were gone before the morning of November 13th, reached its halfway point. Whatever the law delivered, and whatever it fell short of delivering, those names carry the full moral weight of everything this case has cost, and everything it demands of the systems that exist to prevent it from happening again. The question of whether what was delivered here was enough does not belong only to Idaho. It belongs to every family in this country that has sent a young person to a university and trusted, in the way that parents must trust, that the world surrounding them offers some basic measure of protection. It belongs to every community that has watched a case like this one and felt the distance between what happened and what the system delivered. It belongs to everyone who understands that accountability is not fully served by a conviction alone, that truth requires more than a sentence, and that the names of the people at the center of these cases deserve to be spoken with clarity and held with permanence, long after the legal machinery has moved on to the next file. If you have stayed with Midnight Evidence through both parts of this documentary, you already understand why this case matters beyond the headlines. You understand that covering cases like this one responsibly means refusing to let the story end just because the courtroom chapter has closed. Subscribe to Midnight Evidence right now if you are not already part of this community, and leave your thoughts in the comments below, on the evidence, on the plea, on the questions that still do not have answers, and on what you believe justice in this case actually required. Share this documentary with someone who needs to hear these four names spoken clearly, and come back, because this channel will continue covering this case, and every case like it, for as long as the questions are worth asking. And on this one, they still are.